Okay. Yeah. For me, it's an honor and privilege to be before you. When the Chief Justice asked me to come and make a presentation to you this morning, I had no clue what she had in mind, but one thing I did not take for granted is the principle of the independence of the judiciary. So she did not tell me what to do or what to say. She gave me that independence to decide. Having done that, of course, you know, as the Chief Justice and President of the Supreme Court, once she gives an order, there is no appeal beyond the Supreme Court. So I couldn't say yes or no. I just had to comply. But I'm well guided by this theme. And when asked to speak on the role of the judiciary in corporate governance, I had to take to mind what you have sat here in the last couple of days discussing. And indeed, I do appreciate that governance is a core theme of what makes our existence worthy, our lives worthy living. Because we are alive courtesy of not just our God the Creator who gives us life, but also the institutions that make it possible for us to relate as human beings. And given that kind of background and environment, we then have to ask ourselves, what is it that we do to govern ourselves, to govern our institutions, just so that we derive the best out of our daily lives? And that is why most of you seated here are corporate secretaries, people in governance, in just about every aspect of our daily lives, in state corporations, in companies, multinationals, domestic business entities, and so forth. So you begin to see why governance for us is a very important aspect of our daily life. If you agree with that, then you probably would be asking yourselves, what has the judiciary got to do with this? And I can assure you it's a great deal. Let us first of all begin with appreciating the structure of our judicial institutions, or of our judiciary as established under Chapter 10 of the Constitution. Most of you are fairly familiar with the judiciary as comprised first of the Supreme Court, which is our apex court that deals with not just presidential elections, but also with appeals from the Court of Appeal on matters constitutional. And besides that, of course, matters that are of great public importance or general public importance, and matters that involve county governments. So you are quite familiar with that, I am sure. Below that comes the Court of Appeal, where I serve as a judge of appeal, presently stationed in Mombasa, serving Mombasa and Malindi, after moving from Nairobi, where I began after a long career in teaching law and practice as a chartered arbitrator, and of course, brushing shoulders with quite a number of you here, including one of your council members. Is Wayne with us this morning? My good brother? Right. I am sure he'll be with us. I had a conversation with him yesterday. Then below the Court of Appeal, we have the High Court and courts of concurrent jurisdiction. And by concurrent jurisdiction courts, I am referring to the Environment and Land Court and the Employment and Labor Relations Court. And below that, we have the subordinate courts that are the magistrate courts, Kadis courts, as well as the national tribunals established under the Constitution. Now, the core mandate of the judiciary sits in very well with what you do every day, and basically is to exercise judicial authority, of course, as enshrined in the Constitution. And you well know that Article 159(2) does confer judicial authority on the judiciary, which is derived from the people of Kenya. Of course, the other key role is the administration of justice, and this spans social, economic, cultural, and political life, just so that in every aspect of our area, of our lives, public and private, you find judicial intervention where disputes arise. It does so in accordance with the principles enshrined in Article 159 of the Constitution, again, expedition, fairness, and so forth, and quite a number of other things that we are all familiar with. Now, the role of the judiciary in corporate governance and the role of the judiciary in economic development is something that will be of interest to you all. And I am sure many of you do have familiarity with what we are talking about here. And as I prepared this paper, I had no intention of making it an academic expose, but perhaps just pointers to prick your minds in things that we will be discussing today at a very casual level. Now, the general functions of the judiciary then include the general administration of justice, and you know that anyone who seeks justice will always go to a judicial institution, if not to one of the peripheral dispute resolution avenues, including mediation, arbitration, conciliation, and so forth. And those in the building industry know that ADR plays a significant role in the administration of justice in the in the built environment. The judiciary also deals with conflict management and dispute resolution. What do we mean by conflict management? Perhaps you know, as we will see shortly, that we always live in an environment of conflicting interests. Even as you sit beside your neighbor, you have conflicts as between the two of you, or the three of you, or the four of you, including those seated in front and behind. You have to choose where to sit, isn't it? You have to choose who to sit with, and you probably made a choice that conflicted with the choice of another who wanted to sit beside perhaps a handsome young man, or or a beautiful young lady, or a wise gentleman like our chairman, or as a mature sister with whom we would converse and gain a great deal of wisdom from. So we always live in an environment of conflicts. And there are many ways of resolving conflicts, or rather managing conflicts. But when conflicts escalate, then we have to look for ways of resolving them, and that is when many will then run to the judiciary. But above all, you will have realized that in your day-to-day assignments as corporate governors, you will find that judicial intervention, when sought, it just about almost always influences our social, cultural, social, and political policy development. in just about every aspect of our lives. The decisions that we make every day are influenced by the way decisions are made by courts that we approach to resolve certain disputes. You know by now that when you go to court, have a case determined, that decision guides decisions of other players in our socioeconomic, cultural, and political arena from then going on, unless that decision is reversed. Just so that the judiciary then is seen to have influenced decision-making process by setting ground rules that are not spelled out in statute law. The judiciary as well upholds the rule of law. Can you imagine a community or a state that has no rule of law? There are quite a number of them today. There are quite a few where people run amok. If you look at the DRC, for example, and I hope there is no diplomat from the DRC, just that I will never get a visa to visit that beautiful country. At the risk of that, I will say this: you will find war-torn countries that in which people wake up in the morning just to pick arms after making sure they have enough to eat for the day. They will pick arms and go into the neighboring villages to loot and butcher each other. That happens in places that we have heard of, places that we have seen, be it in Sudan, be it in Darfur, be it in the DRC, or other countries where the rule of law has really broken down. What would you expect of a state of that nature? Most definitely, economic development would be the subject that is least spoken of, because the breakdown in the legal infrastructure and the institutions makes it impossible to foster any economic development. And that's where poverty sets in with all its weight. That is where the sun rises for the sake of nature and not for the people that live in such countries. So you begin to see where the rule of law really makes sense and plays a significant role in our economic development and social stability that we all take for granted at times. And that's why judicial institutions play a significant role in ensuring that we are all governed in ways that make sense, in ways that bring fairness and justice to all. Now, what are the areas where conflicts arise, or where conflicts arise in the corporate governance and economic sectors? There are quite a number of these, and I'll just touch on them in passing. But the conflicts that we are talking about that find their way into the judiciary will almost always arise from the interplay of the four factors of production. What are these? These will be capital, invested in entrepreneurship adventures. There will be land, there will be labor, and the entrepreneurship itself in the nature of the companies that you govern. Their interplay is characterized by competing interests, and there is no question about it. When you think about labor, for example, you've seen the doctors' strike going on for 45 days today or beyond. These are competing interests. Competing interests as between county governments, the national government, and the professionals who are critical in the medical service delivery, on the one hand saying, give us jobs and pay us a decent salary. And the other says, we don't have money for you. And those, of course, will say, we don't have enough money for you. Probably people who are healthy but do not know that tomorrow comes with all its ailments. So you see how competing interests set in, courtesy of those factors of production, land disputes. And such competing interests, of course, will always result in disputes that find their way they find their way into the judicial system. When you have labor disputes, of course, as we will shortly see, we know where to go. And their effective resolution impact economic development. Economic growth and development is impacted by the manner in which disputes are resolved in our courts. Of course, failure to foster that resolution of disputes, of course, will always result in lawlessness. And what development would you talk about if we have a lawless state of affairs? If we have a state of affairs where people settle disputes by duel, the way they used to do it a long time ago. We always read of a situation. I think some of you are old enough to have found Western movies, didn't you? You know those fellows who used to ride around, and when they meet some of their other ranchers with whom they're in competition, all they do is just draw their pistols and shoot each other. And then they drive the cattle away. That is what we are imitating in the Rift Valley, I guess. The cattle rustling rampage that we can hardly ever contain. You can imagine. And I'm not saying that the judiciary is able to resolve some of those conflicts and disputes, perhaps relating to competition that stems from environmental elements where you hardly have sufficient grazing land, sufficient watering holes, sufficient fodder for your cattle. I'm not saying that the judiciary is the place to go for some of those conflicts. That's why we spoke of conflict management through governance structures that themselves must be sound and healthy to ensure that they are able to govern in ways that are productive, ways that are effective, and so forth. So there's a lot to think about this. Now, when you think of all these disputes, let's just categorize them. There will be disputes over land, and that will be perhaps, ownership, maybe leases and things like that. And these are usually resolved by the Environment and Land Court. Then we have employment and labor disputes, usually resolved in the Environment and Labor Relations Court. Those are the two courts of concurrent jurisdiction that we spoke about. Then we have the disputes relating to companies and business enterprises, and perhaps that's what you are most familiar with, in addition, of course, to labor disputes. And these go to the High Court, and perhaps, depending again on their pecuniary jurisdiction, to subordinate courts. I am sure quite a number of you have come across petitions to the High Court to reverse decisions made by certain governance bodies, mainly public institutions, that make certain decisions that don't sit in well with the consumers of their services. And they'll go to court to ensure that there are orders of certiorari made, or mandamus, orders of mandamus to compel them to do certain things in service delivery. When all those judicial institutions do what they must, if we are not happy, then we go to the Court of Appeal. Right from the Superior Court, then we go to the Court of Appeal for appeals, and in appropriate cases, then to the Supreme Court. But the Supreme Court, the jurisdiction of the Supreme Court is exercisable in very limited situations that have to be qualified by a grant of certification by the by the Court of Appeal. Moving on then, we want to take a look at the benefits of an effective judicial system. What are the benefits of an effective judicial system? You find that effective administration of justice will almost invariably promote the protection of labor, protection of rights to fair labor practices, and that impacts your day-to-day activities yourselves. I don't know how many of you have had strikes in their institutions or grievances that you find difficult to resolve. Perhaps you have to sit in with union members to ensure that you reach some agreement on how to resolve some of those labor disputes. Maybe you get into CBAs, collective bargaining agreements, and because you are twisted, you will sign on the dotted line and later realize you don't even have the budgetary allocation to really implement what you agreed on. And a dispute arises and they go to court to do all that. But if we have effective administration of justice, effective exercise of judicial authority by the judiciary, then the other thing you have is industrial peace. And industrial peace, as contemplated in Article 41, and the protection or promotion of the rights of workers will almost always give you the kind of environment that indeed makes good for economic growth and development. When you have social, or rather sound corporate governance, you are happy to work your hearts away and be able to generate resources that lead to economic growth and development. So you begin then to appreciate how our economies are sustained. And I must say that world over today we are struggling to stabilize our economies, aren't we? Mara unasikia shilingi iko above the ceiling, it's gone up to the skies, it's coming down kidogo, but nothing works much, we are back to square one. So we are always fluctuating. It's like a swing up, swing low, sweet chariot, as we used to sing. It's a situation where you do not really know where we will be tomorrow. And that's why political stability also becomes elusive in some countries. Social, cultural, and environmental rights are degraded or eroded, such that our Articles 42 and 43 lack meaning, so that the protection and realization of the rights to property again are undermined, so that Article 40 doesn't mean much to us until the time we have effective administration of justice. You'll agree with me, much as we make effort to, discuss, negotiate, settle disputes within the executive, with interplay, perhaps with the assistance of Parliament, not all disputes will be resolved. Much as there is effort to ensure industrial peace, to ensure that our governance organs are working properly. And there's a great deal of effort because the regulatory mechanisms are there, but sometimes nothing works as well as we have planned it, isn't it? So you find that disputes are always arising, and we are rushing to those who must make binding decisions. And the binding decisions will come from third parties like us in the judiciary. And at the end of the day, one party might like it, another might not like it, but that is the way it is. the administration of justice impels us to comply with the decisions that the judicial authorities make. Now, what are the main areas of intervention in corporate governance? Again, I think you are best placed even to answer this question for me, but you will agree that shareholder derivative actions are really, really common. And you'll find that in any corporate entity, shareholding becomes a sticky thorn, particularly when shares are issued with intent, perhaps to dispossess power from certain of the directors who no longer command a majority following, and they are removed because the shareholding structure has changed so that the voting patterns differ. There is all that, and you find that not all will be happy. And so shareholding also becomes one of the key areas where disputes arise. Disputes may arise in the corporate sector also in issues of insolvency, where perhaps a corporation, whether a state agency or a public company undertakes business, runs short of capital, starts squabbling just about every cent that comes their way, doesn't deliver services, doesn't pay debts, and we've seen huge corporations go down into insolvency. It could be statutory management, perhaps under a process that seeks to rehabilitate such corporations, but it could as well be receivership, and sometimes corporate restructuring, and where the restructuring is not possible, you find that there are winding up proceedings that will also be challenged from time to time. Maybe dissolution and winding up, again, not to the liking of some of these companies, but you find also judicial intervention where we are dealing with mergers and acquisitions that we are all familiar with. It could be regulatory compliance. Some of the corporations have not complied with the statutory regulations, policies, mwongozo and the likes, and you find the decisions they make are challenged. And at the end of the day, you are in court waiting for the decision by the judges. It could be disputes relating to corporate tax and liabilities. And again, you know what happens when we are able, you know what happens when we are unable to fulfill our tax obligations. KRA comes in, you find yourself before the tax review tribunal, and you have to appeal their decision to the High Court, eventually to the Court of Appeal. And those are some of the exercises that are not very pleasant, but thank God our governance structures now are such that KRA and the tribunal and other players have relaxed their muscles a little bit. They are able to agree even for payment of taxes by installments. And I'm sure some of you have been beneficiaries of this. When you do an in-depth assessment and you find that you owe KRA some money, they just ask you, how much do you think you can pay monthly and how long do you think you will take to settle this debt? And it's not very difficult to reach some agreement. Now, you might ask ourselves, why are we discussing all this? What does corporate governance got to do with all these judicial decisions? Just to give you an idea, if you look at 4 cases that I will mention here, you will see how landmark cases have shaped the way we administer our institutions. Are we familiar with the case involving the CMA and the CMA Tribunal, and 4 others. This was a 2018 case that dealt with the regulatory authority of the CMA. Again, when that authority was challenged, a decision is made, and the authority, once spelled out, one is able to go by 8. But if you not come across that, you wouldn't be sitting here without ever having come across the celebrated case of Solomon versus A. Solomon and Company. It's an 1897 case that did recognize the legal personality of a company. And today, ask anyone in the business world, he will tell you, I want to register a limited liability company. Why? Because I don't want to bear on my shoulders the debts of my business. I want a company to shoulder its liability, so that the corporate personality of the company, clearly spelled out, helps us undertake business without risking our own personal liability or responsibility, courtesy of a business that is run as a separate entity. An example of the case of Queen and Axton Limited versus Salmon, again 1909, I think it was. Again, a case that related to the to the enforcement of the company constitution, where shareholders come in and say, in our memorandum and articles of association, this is what we've agreed. And matters can't run, directors can't run amok and decide what they need, what they want to decide, while we have a situation where we need to be sure that the company constitution is observed. Bushel versus Faith in 1970, again, an English case that guides us in ways that we go when we want to remove directors by simple majority vote of shareholders. I mentioned these cases because a great deal of our company law really is borrowed from precedents in the English common law jurisdiction that we followed all along. Even when you look at our own Companies Act, you will appreciate how far we have gone in observing some of those set principles. And of course, we are not here to reinvent the wheel. The principles set in those judicial precedents guide us to this very day. And even as we make our decisions in the High Court, in the Court of Appeal, in the Supreme Court, we are conscious of what courts have decided elsewhere in the wider common law jurisdiction, whether it's in England, whether it's in India. And even as recent as this year, we still are taking lessons from even the American jurisdiction that helps us to see how judicial intervention has helped to shape our economic growth and development. Now, judicial intervention in investment disputes is yet another area that helps us to see how the judiciary has played a critical role in the determination of disputes, and examples are disputes relating to investment agreements. And let me pause here for a moment. We have had international players coming in and saying, we've got billions of dollars to invest in Kenya. However, we are not very happy with your judicial system, because in case of disputes, cases are taking 5-10 years to resolve, We do not think that's the way to go for us unless we enter into investment agreements that will dictate that if disputes arise, they will be resolved at the international, at the international level, either the London Court of Arbitration or the international, what do you call this one in France? Sorry, escapes in my mind. ICC, yeah. And when you look at that scenario, you begin to appreciate the importance of effective dispute resolution, the effectiveness of judicial intervention in the resolution of investment disputes. Why? Because no one wants to see their capital tied into a big dispute. As I see sometimes here, we are talking of hundreds of millions of dollars in dispute here, and it taking 5, 6, 7 years to resolve, and a company is waiting with its money tied up before a decision is eventually made. And that is why ADR, which we will mention shortly, plays a significant role in ensuring that dispute resolution is effective, just so that we don't tie capital and have capital released efficiently to do what it must do to foster economic growth and development. Others are disputes relating to shareholding, perhaps stocks and securities, and those securities may include perhaps charges and mortgages, floating charges and things like that, and the dispute resolution also relating to ownership, perhaps leases of a land and other things such as other immovable property management and things like that. So when you look back, when you reflect on what the judiciary is tasked to do, you begin to see how it touches on just about every aspect of our corporate governance, every aspect of our economic growth and development, every aspect of what it means to have a ticking economy, just so that at the end of the day, we do not think that we are collapsing, that we have nowhere to go, and that the best we can do is to pick swords and meet on a courtyard and duel, see who kills the other first. Let me share this quote, anonymous. Judicial intervention in corporate governance can serve as a catalyst for economic growth by holding corporate actors accountable, fostering a culture of compliance and protecting the interests of shareholders and stakeholders. You'll notice some key words here. Accountability. Isn't that what we really want to see every time? Regulatory compliance. That's why we have compliance mechanisms that call on agencies established to ensure just that, getting up to see who is complying, who is not. Again, we see that central to all this are the rights of shareholders and stakeholders. And the stakeholders may be mere, and I'm using this word mere very lightly, consumers, service consumers of the services, such that if For example, your power is not generated and distributed in good time to ensure that your factories run, we have a problem. So people rise up and say, who is accountable for this? Not so long ago, we had a fuss kicked over the power blackouts, including places like the airport, the international airport at Nairobi. Who is accountable? And someone lost their jobs. And it is that accountability and regulatory compliance that we are talking about here, so that the role of the judiciary in the maintenance of law and order, in maintenance of industrial peace, maintenance of systems that ensure that things are done right is critical to sound corporate governance and to economic growth and development. This calls for effective resolution of disputes, including labor disputes, including land disputes by the ELC, including industrial, disputes arising from industrial action and the withholding of labor and so forth. So that labor unrest will definitely call for some management of sorts, some resolution, just so that we don't have people out there, workers out there rioting in strikes and so forth, and at the same time ensure that we also have their rights guaranteed, just so that at the end of the day, the economic growth is not just the growth of the entrepreneurs, but those who invest labor as well. Now, I am sure we are familiar with the kind of labor disputes that confront us almost every other day, to be disputes over salary, wages, and conditions of employment. And we even have a statute that deals with conditions of employment. Enforcement of collective bargain agreements has been a sticky thorn, and we find trade unions and other labor institutions locking horns in our ELRC. It could be cases of unfair termination and wrongful dismissal. We face those just about every day, and again, they contribute to the integrity of our governance in those institutions, the integrity of economic development and so forth. So it could be, union recognition and as well as industrial action and the withdrawal of labor when things really get to the very worst. Now, we've said so much about judicial intervention, but that the judiciary join hands with other peripheral initiatives to ensure that you don't always have to go to court. Yes, the judiciary promotes alternative dispute resolution in the administration of justice. And that's why the recent initiatives for court-annexed mediation has played a significant role in ensuring that it's not always the decision of the judges that might carry the day, but that parties are given the opportunity to come together and, reach a resolution that they can all live with. Again, not taking hard positions in law, but just sitting together. And I don't know, I'm sure, could I hear yes if we have some mediators amongst us? Yes, we do. Great. Even in the Court of Appeal, as we see it, every day we ensure that when an appeal comes before us, the first thing we do is to try and explore the possibility of the parties agreeing. And more often than not, the most intricate, the most complex of the appeals can be resolved by a very easy process. In fact, they say that the most complicated of problems have the easiest solutions, isn't it? When I did mathematics in high school, I remember there's one sum in integration. We really wanted to calculate and see and be able to come up with a solution as to when a certain person died or was killed. And it took us more than half a term to try and, with all those derivatives and integration formulas to come up with the time when this gentleman was killed. We couldn't, so we closed the school. And it occurred to some of us, I don't want to say me, over the holidays, to actually realize that it was a very simple calculation. And when school opened, we were all in class with this Ugandan teacher of ours asking, did anybody figure out when this fellow died? And say, yes, this is the time he died. How do you come to that? Very simple. And we have to accept that ADR is the simplest of all dispute resolution mechanisms that we must embrace as a first port of call, so that court intervention becomes the last, the last resort. And that is why the judiciary promotes ADR, but nonetheless does support the arbitral proceedings under the Act, under the Arbitration Act. Again, there are situations where court intervention is required, particularly to stop proceedings in court, just so that people are sent away to go and comply with their arbitration agreements. The courts play a significant role in the recognition and enforcement of arbitration awards. And this could be domestic awards, this could be international awards under the New York Treaty for Recognition of foreign awards, such that at the end of the day, whether we are talking about judicial intervention by direct administration of justice through the courts, or whether we are talking about promotion and support of arbitral proceedings or other ADR mechanisms, at the end of the day, we are able to see how the judiciary plays a significant role in corporate governance and economic development. What are we saying here? Just a minute. Did I lose something? Now, yes, I seem to have. It seems to have gone where it ought not to go. But at the end of the day, we are happy to see how the judiciary has played a very significant role in ensuring that whether it has direct intervention itself or whether it has invoked other mechanisms, we are indeed able to ensure that we have corporate governance properly reined to ensure that our economic development is on course. We are done with that. Just a minute, I'm just searching where we are. Sorry. Some of these gadgets, you just touch the wrong button and it takes you to the polar region and back. And by the time you are back, you have quite a bit of time. So then what we are saying here is that the minute you come to court, you find yourself faced with two options. Either to let the judicial system make decisions for you, or be encouraged to make decisions with which the with which you can live as between yourselves and the contending parties, so that alternative dispute resolution also becomes something we promote. And I've met quite a number of you who are seasoned arbitrators and are able indeed to motivate. Let me conclude by saying this, that you and I can build a prosperous nation if we want to. You and I can bring our nation to its knees, and many have tried and succeeded. And that the wealth of our nation is really determined by, our ethical and governance standards. So the question is, do we set our standards to such levels as to be exemplary? What is it that is our strategy? Of course, noting that the choice is ours, there are those who make a very simple choice that I am here as the CEO, I am here as the CS, mine is to grow very rich. And by the time they realize that this corporation has sunk, I will be living in my mansion. Where do they go to buy houses nowadays? Yeah? Dubai. Some of you seem to know. So which way do we go? And this is a very personal question. Which way do we go? And for a long time, those of us who sat out there to see what corporate governors are doing with their institutions, what players in county governments are doing, what others in key positions in government are doing, we kept on wondering, can there be a better place to live? Is this all there is? I say this because the graft cases that plague the judiciary today are actually on the rise. They are an indicator of where we are today. And I'm sure you read in newspapers to see a fellow who earns 60, 70,000, 160,000 shillings is a multi-millionaire, a multi-billionaire. I don't drive, so I don't even know how to drive one car, let alone 17 cars. But there are those who are ambitious enough, and that greed gets into us in ways that cleaning up those economic crimes is really an uphill task. And that is our experience. It is difficult because we play to the rule of law, and more often than not, then the judiciary is said to be doing nothing about it. And another day, a colleague was telling us, some of these prosecutors who've been compromised, they come and make sure they compromise their case. So what are we to do? What are we to do? The law says this is it. These are the standards of proof of any case that is a criminal charge. They don't bring half of the evidence. It is hollow. What do we do? But it's always easy to blame the judiciary because the judiciary doesn't hold press conferences kujitetea. Sisi hatujitetei. Hata saa hii sijitetei. So, we are the ones. It is you and I that will eventually determine our destiny. It is you and I seated here, and those out there that will determine the kind of nation we build for our generations to come. But the question is, what role do you play yourself as a corporate governor? What standards of moral integrity do you set for yourselves and observe? Do you live and let others die? You know? I never forget, though. I'm sure most of us read the Bible, don't we? Ever read 1 John chapter 5, verse 19? Who will tell us what it says? 1 John chapter 5, verse 19. That is the divine law wacha hii tuna practice hapa. The whole world lies in the power of the wicked one. Thank you.